You've probably heard the line, "You have the right to remain silent. Anything you say can and will be used against you in a court of law." This is known as the Miranda warning, named after the famous Supreme Court decision in Miranda versus Arizona. Although the Miranda warning clearly applies in criminal cases, parties to civil cases like Michael Irvin's defamation lawsuit should heed the exact same warning that anything they say out of court can and will be used against them in a court of law. Nowhere is this more the case than when it comes to things that they post onto social media. In this video, we'll take a look at Michael Irvin's recent public appearances and his social media activity, and we'll talk about ways in which Marriott and its co-defendants might try to use that evidence against him to undermine his case, to undermine his credibility. Before we get into the video though, I want to make a special announcement. If you want to support this channel and unlock special members only perks, then join my channel membership program today. All you have to do is click the link in the description box below. Now, defense attorneys will often scour a plaintiff's social media account looking for anything that they can use against the plaintiff to either undermine their allegations or call their credibility into question. The complaint that Michael Irvin filed says that he is seeking damages for humiliation, undue stress, anxiety, and mental anguish. During Irvin's first press conference after the NFL Network and ESPN indefinitely suspended him from TV, basically canceled him from TV, Irvin was clearly distressed and fighting back tears. We could all see that, and it seemed to be authentic. It did not look like an act. Host of ESPN's First Take, Stephen A. Smith, and Michael Irvin's friend, said that he talked to Irvin every week after the incident.
"We have spoken every single week since the ordeal during Super Bowl week transpired."
He said that in Irvin's mind, Irvin was fighting for his life.
He is fighting in his mind for his life.
Stephen A. explained that he heard and saw Irvin cry while emphatically proclaiming his innocence.
But in speaking to him, in literally seeing and hearing him cry, while emphatically proclaiming his innocence.
That is compelling evidence of emotional distress and mental anguish. In a tweet earlier this month, Irvin revealed that he was traveling to Brazil because he was in a, quote, dark place, dealing with all that stuff since the Super Bowl, and he just needed to get away. In a moment, however, I'm going to show you how Marriott and other defendants in Irvin's case may try to use other social media posts that Irvin has made to undermine and contradict his claim that he's suffering from mental anguish, humiliation, undue stress, and anxiety. To illustrate my point, let's take a look at two cases where defendants used the plaintiff's social media post against them. The first case I want to look at is EEOC versus Original Honey Baked Ham Company. In that case, an employee filed an employment lawsuit claiming that she had suffered emotional distress because of harassment that she had experienced in the workplace. During the discovery stage of the lawsuit, the employer asked the plaintiff to grant it full access to her Facebook and other social media accounts to search for evidence that contradicted her claim that she was having this emotional distress. The plaintiff, of course, objected to that, and so the employer ultimately went and asked the court to order the plaintiff to grant it full access to her Facebook account and other social media accounts, including any deleted content, private messages, no matter what, they could view it. Now, the court ultimately granted the employer's request for full access to the plaintiff's social media accounts because the public photos and statements on her social media accounts provided, as the court would say, insight into her emotional state and financial expectations in the lawsuit. For example, the court pointed out that the plaintiff had posted statements about how losing a pet and ending a romantic relationship had caused her emotional pain and distress. She had posted photos and statements about her post-termination employment opportunities. She had apparently sent amorous direct messages, DMs, to other co-plaintiffs in that lawsuit, and she had even made statements about her current financial condition and her financial expectations related to the lawsuit. In another case, Romano versus Still case, an office worker had filed a personal injury lawsuit against her employer after her chair collapsed at work. She claimed that she had suffered injuries from the defective chair that had negatively affected her enjoyment of life. The injured plaintiff posted photos to Facebook showing her happy, smiling, enjoying her life, and traveling out of state despite claiming that she sustained permanent injuries and was largely confined to her home and her bed. Not surprisingly, the defendant requested access to the plaintiff's private Facebook page and messages, including anything that she had deleted. The court granted the defendant's request and ordered that the plaintiff had to give the defendant access to all of her private social media content because her public post on social media undermined her claim potentially for damages for mental anguish and loss of enjoyment of life. So with all of that said, I expect that in Michael Irvin's defamation lawsuit, Marriott and its co-defendants are going to use various videos that I have seen on Irvin's social media to try to show that he was just as happy and gregarious after the incident as he was before the incident, notwithstanding his allegations and his complaint to the contrary. For example, in a video posted on Mark Holmes's channel, Irvin can be seen hugging fans at some sort of expo, signing autographs, smiling, and generally he looks like someone who is enjoying his life. On March 26th, Irvin posted a video of himself celebrating his alma mater's basketball team making the Final Four.
Y'all see this? Miami, Coach Lornay, we're headed to the Final Four. That's right. The U. The U is on fire. That's what I'm talking about.
In a tweet on April 4th, it's clear that Irvin is making public appearances and giving back to the community, which is totally admirable and commendable, and I'm not saying he shouldn't be doing this, but this is what Marriott is going to bring up as Exhibit A, that Michael Irvin is not affected whatsoever by this, and in fact, his standing in the community is no different than it was before he was canceled from the Super Bowl and from the NFL Network. More recently, on April 9th, Irvin posted the following video to his Twitter account from Brazil after he was trying to find somebody watching the UFC fight.
Brazil to watch the fight. Oh my God! I don't even know these jokers, but we watched the fight together, and now we on board. Oh my God! We're going to have a three. We're going to have a three, and we all decided before the fight, if there's a three, we all going to it together. We going to it together. I was hiding from these jokers, and they found me in Brazil. God damn, did you see that knockout? God.
Now, don't get me wrong. I fully support and encourage Michael Irvin to continue moving forward, living his life, giving back to the community, and trying to enjoy his life. I am not by any means saying that he should play the victim here or that he should wallow in self-pity, but I fully expect that the defendants in his lawsuit will try to introduce as evidence to a jury his social media posts in support of its argument that he was not suffering any major humiliation, stress, anxiety, mental anguish, or even loss of standing in his community. They may also use it to discover private messages, direct messages that Irvin has been sending via his social media accounts. My counter argument to all of that would be to first acknowledge that yes, Irvin clearly appears to be enjoying himself in the videos that he posted on Twitter. And yes, Irvin clearly does not seem to be in any kind of real distress on those videos, but looks can be deceiving. While these photos and videos may show Irvin smiling and enjoying simple pleasures in life, like watching a good fight, cheering for his alma mater, mentoring young athletes, and giving back to the community, I'm sure that Irvin would say that these fleeting moments of joy were overshadowed at all times by the reality that he may never get to work in his chosen profession again. They're overshadowed by the fact that he, if he's to be believed, he has done nothing to deserve that. He has done nothing wrong. That's a dark reality and one that is probably constantly in the back of his mind, even if he is able to blow off steam every now and then. So let me know in the comments below how much, if anything, you believe the defendants should have to pay Michael Irvin to make up for any humiliation, stress, anxiety, and mental anguish that he has experienced as a result of this whole incident. And of course, as always, thanks for watching.